Good day, Crime Talk aficionados. I don't know about you, but I feel much better today. First on the docket, Bryan Kohberger is going where others have gone before. Will it work? Karen Reed, terrible cross-examination by Mr. Alessi. I guess orange is going to be the new black. Sean Combs wants a mistrial, an unusual video of a police shooting in Miami. Karmelo Anthony, no, not the basketball player, the juvenile accused of murder is going to be charged as an adult. A raid in a quiet neighborhood in Texas leads to the arrest of an FBI analyst. Wait till you hear about what. We have This Day in Legal History. We give you something to think about when it comes to eyewitness identification and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, we've noticed a big increase in the actual downloads on Apple. So thank you. Appreciate everyone going there as well. So when you can't watch us on YouTube, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. And the report is literally prepared while you wait. It is emailed to you. You can get updates of the information if you make that request, and you're going to get a report that's going to have information about the person that you're searching for. For example, you're going to get information about all the email addresses they have, any phone numbers associated with them, their social media presence, any criminal history. Are they married? Are they divorced? Do they have liens, judgments? Do they have a criminal history? And are they on one of those sex offender registries? Yes, ladies and gentlemen, go check the person out if they're coming into your life, or maybe you're just not getting that warm, fuzzy feeling from them. Go to crimetalksearch.com. You're going to be happy that you did. Now, before we get to the docket, I want to give a big shout out to a true Crime Talk aficionado fan. Want to thank this particular fan. I don't have permission to use their name, so out of respect for them, I don't want to do that. But let's just say a big fan yesterday sent me this little pilot. It's a pewter pilot as well as a sign. I appreciate that very much. Thank you. You know, we don't ask for gifts or anything like that. We just hopefully bring you a good product that you want to watch and enjoy. But the fact that somebody would take the time out of their day to spend their hard-earned money and send it to me, thank you. Very appreciated. Unnecessary, didn't ask for it, but thank you. And just wanted to note your gift and your very nice letter as well. We appreciate it. So thank you. And I just didn't want to use your name or your handle just out of respect for you, since you didn't say go ahead and use my name. But thank you. You know who you are. All right, everyone, let's go ahead and open the record for Wednesday, May 28th, 2025. And first on the docket, well, Bryan Kohberger. A couple of recent filings today, literally as I was preparing today's show and I was going through my stack of stuff. But what came up? A motion to seal the defendant's evidence in support of offer of proof regarding alternate perpetrators and exhibits. That's right, comes now, Bryan Kohberger, through his attorneys of record, and hereby move this court for an order to seal the defendant's evidence in support of the offer of proof regarding the alternate perpetrators and its supporting exhibits. So obviously they filed the motion, and then the court granted that motion as well. Another motion to seal objections comes now. Bryan Kohberger, applying through his attorney of records, and hereby move the court for an order to seal the objections to the court's request for the defense to submit a redacted copy of the ex parte filing to the state. Interesting. And the court granted that motion as well. But the interesting thing, ladies and gentlemen, is you would think Bryan Kohberger, all right? Now, I've done lots of criminal cases over 30 years, ladies and gentlemen. That's primarily what I do. I'd say it's 95% of my work is criminal defense work, all right? And if I have an alternate suspect, if I think somebody else did something I am going to attach that to every pleading I have. I'm going to shout it from the rooftops that this is the person who committed the real crime, set my person free. Just like if I had an alibi, I would be telling everybody the alibi, showing it because it's going to be definitive proof that that is not my client. Okay? That's the way you do it. You don't seal it. If I had a smoking gun that said, this is the person that committed the real crime, that committed the crime, the real killer, why would you want it sealed? Unless you know that it's probably going to be denied. I think that's why they're doing it. They're going through the motions, ladies and gentlemen. Who knows? We don't know. And like I said, hey, I'm a defense guy. Been doing it for 30 years. I don't want an innocent person to be convicted. Right? Hold the government to their burden of proof. That is our system of justice. But if you've got the goods to set your guy free, wouldn't you be saying, just like you had, if you had a solid alibi, this is my alibi, go check it out. It's 100% certain. Okay? That's what you would do. Okay? I've told you, if I've had an alibi in my practice over the years and it checks out like thoroughly, we present it to the district attorney immediately, and you know what's happened? Case has been dismissed. You know what happens when we have an alibi where we're going to go to trial and the alibi doesn't check out? It's like, oh, yeah, he was sleeping with me. Yeah, that was it. Never checks out. Never had an alibi win at trial. Because if they were solid, they weren't going to be there. Okay? Same thing with an alternate suspect. You can show that somebody else did it. Maybe reduce your client's culpability. Say, well, at most, here we go. Let's reduce our client's liability. Same thing with an alternate suspect. If you had the smoking gun and say, my client didn't do it, that person did it. Maybe it says, hey, my guy's complicit, but what can I do to help you out so we get the real guy, the real bad guy? Something you want to think about. So we'll see where it goes. Obviously, Bryan Kohberger is given the presumption of innocence. He's entitled to that under the law. And like I said, we want justice to prevail. If the prosecution has got the right guy, present the evidence, prove it beyond a reasonable doubt. If, for example, they don't have the right guy, who would want to convict an innocent person? I'm not seeing anybody's hands go up at all. Who would want to convict an innocent person just because you want some justice? Nobody would require that. That would be completely intellectually dishonest. All right. But we'll give him the presumption of innocence and we'll see how it goes. But in the meantime, let's talk about the alternate suspect defense in Bryan Kohberger's case. And I've noticed it's a striking parallel of some of America's most infamous criminal trials. For example, Bryan Kohberger, obviously the criminology student charged with the November 13th, 2022 stabbing for the deaths of those 4 University of Idaho students, Kayla Gonzalez, Madison Mogan, Zana Kernodle, and Ethan Chapin. And what he's attempting to introduce an alternate suspect defense. Now, the judge says, hold on, we're not going to resolve this at trial. We're going to resolve this early. And only if, and under the legal standard in Idaho, you basically have to prove that prosecution has got the wrong guy. And you have to be able to show that this person had a direct link to the crime. Not just could have, but was involved in it. It's a very tough burden for the defense to overcome. We'll see if they get there. So as Kohberger, who obviously faces the death penalty if he is convicted, his legal team has now claimed to have identified another individual responsible for the murders, though the suspect's identity and supporting evidence remains under seal. This strategic move is obviously intended to cast doubt on Bryan Kohberger's alleged guilt, mirrors tactics employed in several other notorious cases. So let's examine the use of the alternate suspect defense in the Kohberger case and other high-profile trials, analyzing their impact on the outcomes. Obviously, Bryan Kohberger, a new suspect in the Idaho murder case defense team, has asserted that the alternate perpetrator committed the murders of the 4 students in Moscow, Idaho. And with the trial rapidly approaching, this last-minute revelation has introduced significant uncertainty, potentially influencing the jury's perception of the case, has it not? Now, the sealed nature of the court documents limits our knowledge, but legal inference suggests that such a strategy could reshape the trial's trajectory, by shifting focus from Bryan Kohberger to another individual. The effect of this approach remains to be unseen. Now, you also have to remember the defense wants a continuance because they need to make sure they got the real alternate suspect. You'd think you'd want to rush this immediately. If you can show the real killer has done it, would you not? But no, they're still asking for the continuance. Let's see how this has played out before. We've talked about the other day, the O.J. Simpson case. Remember that one? Probably a lot of you weren't even born yet, but the O.J. Simpson case, the Colombian drug lord theory. That's right. Back in June of 1994, Nicole Brown Simpson and Ron Goldman were found stabbed to death outside Brown Simpson's Los Angeles home. O.J. Simpson, the former NFL star, became the prime suspect and was famously acquitted in what was dubbed the trial of the century. His defense team, led by the then alive Johnny Cochran, proposed that Colombian drug lords targeted Brown Simpson's friend Faye Resnick over a debt were responsible for the killings. This alternate suspect theory, combined with the other defense tactics, such as highlighting racial bias in the Los Angeles Police Department and demonstrating that gloves allegedly worn by the killer did not fit Simpson, contributed to the acquittal. However, a civil jury later found Simpson liable for wrongful deaths, ordering him to pay $33.5 million to the victim's family. Amount ever paid? I think it's zero, except maybe his estate will have to pay a little something now. Next, Alec Murdaugh, the cousin Eddie and the mystery shooter. Remember, in June of 2021, Maggie and Paul Murdaugh were shot dead at their family's South Carolina estate. Alex Murdaugh, the prominent attorney, was convicted in 2023 of their murder and sentenced to life in prison. Now, during the trial, his defense suggested that Curtis' cousin Eddie Smith, a distant cousin of the alleged drug dealer, was involved, citing Smith's failure of a polygraph test. The defense also proposed that two unidentified shooters, one significantly shorter than Murdaugh, carried out the killings. Supported by expert testimony on bullet trajectories was their claim. These claims were met with skepticism, and the prosecution successfully countered by introducing evidence of Murdaugh's financial crimes and staged murder for hire plot, leading to his conviction. Then we had the Delphi murders, right? The Odinist cult allegation. Richard Allen was convicted in 2024 of the 2017 murders of the teenagers Abby Williams and Libby German in Delphi, Indiana, and was ultimately sentenced to 130 years in prison. Now, before his trial, Allen's defense alleged that the girls were killed by an Odinist cult in a ritualistic sacrifice, naming 4 local men as suspects and pointing to pagan symbols at the crime scene. The judge, however, ruled that the theory was inadmissible due to insufficient evidence linking the alleged Odinist to the crime. The exclusion of this alternate suspect narrative did not prevent Allen's conviction, underscoring the challenges of presenting such theories without robust evidence. And then we got the Karen Reed case that's going on right now, which we'll talk about in a minute. But Karen Reed is alleging a conspiracy of corrupt cops, remember? Now, Karen Reed faces charges in the January 2022 death of her then boyfriend, Boston police officer John O'Keefe, who was allegedly struck by her SUV during a snowstorm. Her defense contends that O'Keefe was killed inside the home of the Albert family and his body was then dumped outside, obviously framing Karen Reed in a conspiracy involving law enforcement officers Brian Albert and ATF agent Brian Higgins. This theory was presented in her first trial, which ended in a mistrial in 2024. In her second trial, which began in April, the judge permitted the defense to implicate Albert and Higgins, but barred accusations against another individual, Colin Albert. The outcome of this strategy remains pending, obviously, because the trial is still ongoing, which you can watch from beginning to end here on Crime Talk. Hey, let's not forget about Scott Peterson, the burglary gone wrong. His theory. Scott Peterson was convicted in 2004 for murdering his pregnant wife, Lacey Peterson, and their unborn son, Connor, in Modesto, California. His defense argued that Lacey was abducted by burglars who broke into a neighbor's home, suggesting she confronted one of the burglars while walking the family dog. Now, despite the alternate suspect theory, Peterson was sentenced to life without parole after the initial death sentence was reversed. Decades later, the Los Angeles Innocent Project took up his case, citing new testimony about the alleged burglars and highlighting the enduring appeal of such defenses in challenging convictions. Conclusion: that's right. The alternate suspect defense as employed by Kohberger's case and trials of Simpson, Murdoch, Allen, Reed, Peterson represent high-stakes legal strategy, which is aimed at creating reasonable doubt. While successful for O.J. Simpson, it failed to sway the jurors in the Murdoch, Allen, and Peterson cases, and obviously we'll see how it impacts the Reed case as well. Now, the Kohberger case, with its sealed evidence and upcoming trial, will test the efficacy of this approach once again, and these cases show a dramatic potential for alternate suspect defense to influence trial outcomes. Well, we'll just have to wait and see how it turns out. Next, the Karen Reed trial. All right, now, well, let's go through this and then I'll talk about it. All right. So Karen Reed's trial is entering its 22nd day as prosecutor Hank Brennan is set to continue his examination of Dr. Judson Welcher, an accident reconstructionist and biomechanical engineer with Aperture LLC. Now, Welcher testified Tuesday that Reed's car didn't log a collision on the morning of O'Keefe's death. However, Welcher said that data only registered crashes between cars and not between cars and pedestrians. Question: were you surprised that there was no information about a collision in the black box? Asked by Brennan. Mr. Welcher: no. It's exactly what I expected. Now, Karen Reed blasted the prosecution's case against her following a full day of direct examination from Dr. Welcher on Tuesday, and Reed criticized a video showing the court depicting Welcher's painting the taillight of a Lexus SUV before brushing up against the vehicle to mimic the alleged vehicle strike of John O'Keefe. The speed, the positioning, Reed told reporters, recreate that for us. Back up into a crash test dummy at 24.2 miles an hour in the arm and see what happens. That's what I would want to see if I were you. Well, Welcher testified that the scratch marks found on O'Keefe's forearm were a result of coming in contact with Reed's taillight. Pointing to his own experiment, Welcher told the jury he is roughly the same height as O'Keefe was, and when he came in contact with the taillight, the paint residue was in the same area on the arm as O'Keefe's injury. So he tried to dress identically to John O'Keefe, Reed said, but didn't do anything else to mimic what the Commonwealth is accusing me of, she said. Now, Karen Reed, obviously given these before and after trial interviews, is going to come back and bite her, ladies and gentlemen. I do not know why her attorneys are allowing her to talk. Any defense attorney worth your salt tells your client to shut the F up. Don't talk to anyone. Anything you say can and will be used against you. Anyone, as we've seen by all of her press interview statements being played to the jury. Now, today, Karen Reed arrived at court with her defense team ready to cross-examine Mr. Welcher. Now, the prosecution is expected to rest their case this week, and then Reed's team is going to begin the groundwork for their defense. Now, obviously, she's accused of killing Mr. O'Keefe in a drunken rage outside of a house party in the early morning hours of January 29th of 2022. However, Reed's defense team insists that she never hit O'Keefe, which obviously goes against some of her own statements, goes against some of the evidence, and she also admitted to drinking, and the blood test shows that she was intoxicated. Now, even by her own admissions, before she went home and drank even more. So, a lot of places, vehicular assault, strict liability crime. Knowingly injure somebody while you're drunk, boom, vehicular assault. It's the second degree murder that shows the intentional or reckless disregard that she's being charged with. Anyway, the judge issued a ruling allowing Dr. Welcher to testify that his investigation found that the damage to Reed's SUV to be consistent with being in the collision on January 29th, 2022. The judge also decided that Welcher can testify that John O'Keefe's injuries are consistent with being struck by a Lexus that is physically identical to Miss Reed's Lexus. This opinion is based upon, among other things, his experimental work that came into evidence without objection as to his scientific methodology and application. the judge noted. The judge then sided with the defense by ruling that Welcher cannot testify that Reed's vehicle specifically collided with O'Keefe's. The jurors are the ones that are positioned to draw or reject that inference as the expert. The judge noted that is the inference is not compelled by the application of any scientific method. So basically, it's a question of fact. The jury gets to decide what weight and credibility to give to Dr. Welcher, to accept his opinions, his conclusions, his analysis, or they can completely reject it. It's ultimately up to the jury. That's what questions of fact and the fact finder, the jury, gets to decide. Anyway, it's also noted that the district attorney's office will pay for the Lexus used by the Good Doctors company for testing in the Karen Reed case. When asked by the defense attorney, Robert Alessi, Welcher said that the district attorney's office previously amended his contract with his company to include that it would pay firm $325,000 to cover his cost testing as well as the cost of the Lexus used in the testing. The firm plans to sell the Lexus following the trial, with Welcher saying the difference will be paid by the district attorney's office. Alessi said Aperture had been paid $44,000 for its work thus far. Okay, let's talk about Alessi. Smart guy, let's give him that. Okay, cross-examination thus far, atrocious. Okay, this is an expert. I was taught years ago when you deal with experts, you're never going to win. And the person that explained this to me said, if you are going to wrestle with a pig, you're only going to get muddy. Okay, and what my mentor meant by that was that he's an expert. He's gonna know more than you, okay? And so the reason what you do then is you want to talk about what they didn't do, okay? And so normally what you do when you have an expert like this, and you know, Karen Reed has all the experts in the world, that cross-examination should have basically been written by the defense experts to say, well, you didn't consider this. This is your flaw, right? And you get them to agree. You get Dr. Welcher to agree. No, I didn't consider this. No, I didn't do that. No, I didn't take that into consideration. No, that wasn't a factor. And you get a good cross-examination when the answers are either yes, 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 or no, 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 no. And you have to control the witness. Alessi's asking these open-ended questions that's letting Dr. Welcher just give an explanation, which makes him seem quite credible and very knowledgeable. And this witness may be the one, if the prosecution can prove their case, may be the one that sends it over to proof beyond a reasonable doubt. Cross-examination thus far, still ongoing, has sucked thus far. So I know all the Karen Reed can do no wrong group will say, oh, Scott, you don't know what you're talking about. He should have done that test at 24 miles an hour. Really? Would you be struck by a car at 24 miles an hour? Of course you wouldn't. It's a demonstration to say, though, because he said there's no way we can know exactly the way things line up. But I have dealt with these biometric engineer guys, I'm telling you, and these catastrophic engineers that recreate things, they're smart people. And the defense allowed this guy in. And if they said or thought that the way he went about his testing was somehow completely flawed, then they should have had a Daubert hearing beforehand, and they never challenged it. So take it for what it's worth. Terrible cross-examination. We'll continue to watch, see if it gets any better. Next on the docket, Sean Diddy Combs. The sex trafficking and racketeering trial intensifies in its now third week. The trial of Sean Diddy Combs, now in its third week at a Manhattan federal courthouse in New York City, continues to captivate public attention with explosive testimony and dramatic courtroom developments. Now, the music mogul faces charges of racketeering conspiracy, 2 counts of sex trafficking, and 2 counts of transportation to engage in prostitution. He's also accused of orchestrating a criminal enterprise to fulfill his sexual desires through coercion and abuse. Now, Combs has denied all of the allegations, and his defense admitted, hey, there may be a little domestic violence in there, but that doesn't mean we're involved in sex trafficking or racketeering. Let's be for real. Anyway, some of the key testimony and witnesses jurors have heard from over the dozen witnesses include Combs' ex-girlfriend and primary accuser, Cassie Ventura, former bandmate Don Richard, rapper Kid Cudi, or Cudi, C-U-D-I, doesn't really matter, and ex-assistant Capricorn Clark, and prosecutors have centered much of their case on allegations that Combs physically and sexually abused Ventura for years, coercing her into sexual encounters known as freak-offs with men who paid thousands of dollars to participate. Testimony from Ventura and others has painted a picture of a controlling and very threatening environment, with stylist Deontay Nash recounting a 2014 incident at the Vanity Fair Oscar party where Combs allegedly assaulted him over Ventura's hairstyle, only to later retract his criticism. Now, Nash, who worked with Combs and Ventura from 2008 to 2018, testified reluctantly, detailing threats Combs allegedly made against Ventura, including withholding her music releases, threatening her parents, jobs, and distributing explicit videos to their workplaces. Meanwhile, Clark's testimony included claims of being kidnapped twice by Combs or his associates, though her account of a 2011 incident involving Kid Cudi was contradicted by LAPD officer Ignacio, who denied witnessing a car chase she described. Now, the rapper's car bombing allegation was a significant focus and has been the January 2012 arson incident involving Kid Cudi's Porsche, which Cudi attributes to Combs as retaliation for his relationship with Ventura. Now, the LA Fire Department arson specialist Lance Jimenez testified about finding a Molotov cocktail, a 40-ounce malt liquor bottle filled with gasoline in the vehicle, which caused minimal damage compared to typical arson cases. Jimenez noted that a fully ignited device could have set the entire home on fire. Photographs presented to the jury showed the car's charred interior and a hole in the convertible roof, supported by the testimony that the explosive was inserted deliberately. Now, the defense also sought a mistrial. The attorneys moved for a mistrial after prosecutors questioned Jimenez about destroyed fingerprint evidence from the arson case. The defense argued that the prosecution's line of questioning implied Combs' involvement in the evidence destruction, which Jimenez attributed to the LAPD authorization in August of 2022, calling the suggestion outrageous. The defense claimed it prejudiced the jury. However, the judge denied the mistrial motion, allowing the trial to proceed. Now, despite the gravity of charges, Mr. Combs has displayed confidence in court, engaging actively with his 9-lawyer team, passing notes and suggesting evidence based on his personal recollection. Sources described him as the quarterback for his defense, leveraging his intimate knowledge of the events to guide their strategy. His charisma has been evident with gestures like heart signs to the audience, though his behavior has drawn scrutiny amid serious allegations. Now, the trial has also produced a lighter but startling details, such as testimony about Combs' unusual cheeseburger toppings, which reportedly disgusted jurors. These moments, alongside graphic evidence of intimate texts, have fueled public fascination with the trial. Now, ongoing support. Oh, and just so you know, what does he like on his cheeseburgers? Applesauce. Yeah. Anyway, Combs' mother, Janice, has been a constant present at the courthouse, signaling his support from his family, and her son faces these obviously possibility of spending the rest of his life in prison. Now, the racketeering and sex trafficking charges carry a minimum of 15 years in prison, while the prostitution-related charges could add up to another 10 years. Prosecutors allege that Combs used his business empire to facilitate a year-long criminal operation, coercing victims into drug-fueled sex parties and silencing them through threats and violence. Now, Combs maintains that all of these encounters were nothing more than consensual acts of sex. Anyway, the trial is expected to last at least 6 more weeks. We'll bring it to you, ladies and gentlemen. I wish this one was being allowed to be recorded, videoed, so that we could see it. One of these days, the federal courts will finally get on board and say, hey, we've got nothing to hide up here. Let's show the world how it is done. One of these days, federal court, we're waiting for you. Next, Miami police officers fired on a driver outside of a music festival near the Bayfront Park in Miami, Florida. Now, according to police, an officer was directing traffic when a man driving a car made contact with the police officer. Now, according to both the officer and the driver, they were sent to the hospital. The driver, a 21-year-old man by the name of Menelik Clark underwent surgery. He was in critical but stable condition, as reported by the police. And apparently a family member said, "My brother does not have a weapon on him. There's no weapons, nothing." His family noted he wasn't carrying anything, but when he got out of the car, he was in shock because he just got shot. Take a look at this video. I'm not exactly sure where I see the shooting take place, but why is he trying to hit the police officer? And the police officer shoots him, I guess, from through the windshield? I don't know, ladies and gentlemen. Only in Florida? I don't know. Next, let's talk about Karmelo Anthony. No, not the basketball player. The teen accused of murder in Texas. That's right, ladies and gentlemen. Karmelo Anthony, the teenager who just turned 18, faces increased legal challenges following the April 2nd, 2025 stabbing death of 17-year-old Austin Metcalf at a high school track meet in Frisco, Texas. Initially charged with first-degree murder as a juvenile, Anthony now faces new charges as an adult, prompting speculation about the potential revocation of his bond. Now, the case, which has drawn a lot of attention, continues to stir controversy over issues of race, privilege, and justice. Now, the incident occurred at a high school stadium during a school district's 5A track meet. And according to the court documents, Anthony, then a student at Frisco Centennial High School, was seated under a tent designated for Memorial High School athletes, where Metcalf was a junior. Apparently, there was a verbal altercation and ensued, and Metcalf asked Anthony to leave, escalating when Metcalf allegedly pushed Anthony. Witnesses state that Anthony then retrieved a knife from his bag, warned Metcalf, "Touch me and see what happens," where he then proceeded to stab him once in the chest. Metcalf died at the scene in his twin brother's arms. Anthony was arrested and reportedly confessed, stating, I'm not alleged, I did it," while also inquiring if his actions could be considered self-defense. Now, Anthony was initially held on a $1 million bond, which was reduced to $250,000 back in April by the judge, citing his age, lack of criminal history, and community ties. He was released on house arrest with an ankle monitor, but recent developments indicate that the prosecution has filed new charges, treated Anthony as an adult due to his turning 18. This could lead to the potential revocation of his bond pending the case through trial, though no court rulings or motions have been filed as of today's date. Now, a significant aspect of the case is the substantial financial support that Anthony's family has received through Give, Send, Go, a fundraising website, which has raised $533,000 as of yesterday, with a goal of $600,000. Now, the fund is administered by Anthony's mother, Kayla Hayes. The fund is intended to not only be used for legal defense, but also for relocation, security, counseling, and living expenses due to reported threats against the family. The defense claim of financial hardship during the bond hearing drew scrutiny, as they were residing in a $900,000 rented home in Frisco's gated Richwards community. Following the alleged racist threats, Anthony and his family relocated to an undisclosed location for safety. The fundraiser has sparked debate, particularly as the GoFundMe for Metcalf's family has raised $558,000 from over 12,000 donors, highlighting the community's divide down there in Texas. Anyway, some people are arguing that the funds for Anthony's reward criminal behavior, while supporters, including the Next Generation Action Network, assert that the money addresses broader family needs amid harassment. Everyone's entitled to a defense, ladies and gentlemen. You may not like it. Anybody can contribute to anybody's defense if they choose to do so. And everybody's entitled to a defense, and everybody's entitled to a lawyer. Anyway, the family's spokesperson, Minister Dominic Alexander of the Next Generation Action Network, has been a vocal advocate addressing alleged misinformation and threats. However, Alexander's criminal history has raised questions. Public records indicate he has faced charges in the past, including theft and evading arrest, though no specific details have been disclosed. These prior legal issues have not been directly linked to Anthony's case, but have fueled public disclosure about the credibility of the family's representation. Now, the school did let Mr. Anthony graduate to receive his diploma. He was a 3.7 GPA student, and he completed all the requirements. So I get why they said, you've earned it, you can graduate. But he was not able to walk through the graduation ceremony due to the pending criminal charges. But that drew criticism, saying, how could you allow him to do that? He earned his degree, ladies and gentlemen. Let the kid graduate. He'll have his day in court, has nothing to do with it. The court said, or the school said you couldn't go through with graduation ceremonies because you have a pending criminal case. I get that as well. Seems like it was a fair compromise. Anyway, the district attorney is preparing to present evidence to the grand jury, which will happen sometime in June to determine whether Anthony will ultimately be indicted. The new adult charges could result in harsher penalties if convicted, and the potential bond revocation looms as a critical issue. Anyway, both families continue to face online harassment, including swatting incidents targeting the Metcalf family and doxing of Judge Tucker, prompting investigations by the police and the FBI. We'll see how that case goes, ladies and gentlemen. I'm not sure if somebody shoves you that necessarily amounts to self-defense. Obviously, self-defense is that you can defend yourself if you're in fear of threat of death or serious bodily injury. However, you also have to use reasonable force to defend yourself, right? You can't escalate it from I'm going to punch you in the nose to bang, you're dead. It doesn't work that way. Great scene, right? Obviously from Raiders of the Lost Ark years ago, where the guy's out there with the knives, boom, 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 and then, what's the guy's name? Harrison Ford, the doctor that he plays, just pulls out a gun, boom, shoots him, right? Probably reasonable under those circumstances, right? That's good self-defense. Had deadly weapon, boom, 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 boom. But when I'm saying I'm going to punch you, you don't get to pull the gun out and punch some and shoot somebody. So there you go, ladies and gentlemen. We'll follow that case. I think it's going to get ugly, ugly, ugly down there. Let's see where the facts lead us before we make any judgment on the case. Certainly you can do whatever you want, but, let's see what comes out, and then we'll adjust based upon new information. All right. Next on the docket, a peaceful community gets a raid by the FBI, raiding one of their own. That's right. An FBI analyst shocking fall from grace in a Texas takedown. In a plot twist that could make even the most seasoned crime drama writer blush, an FBI analyst found himself on the wrong side of the law in Cypress, Texas. Brian Vincent Rausch, a seemingly unremarkable employee at the FBI's Houston office, was nabbed after police uncovered a stash of videos so vile they made a horror movie look like a Pixar flick. On Tuesday, the Montgomery County Precinct Constable Office swooped into Rausch's suburban abode, where they discovered multiple videos depicting child assault. The results? 7 counts of possession of child pornography slapped on Rausch faster than you can say plot twist. 5 of those charges are state level, 3 first-degree felonies, and 2 second-degree ones, plus 2 federal charges for good measure. It's a rap sheet that could look like a grim laundry list. Anyway, neighbors clearly not privy to Rausch's dark side were left gobsmacked as the police raid unfolded like a scene from a blockbuster thriller. They brought the wife out first, left her in the driveway with some agents, then escorted the kids out, said a neighbor and a realtor who sold Rausch's home 11 years ago. We couldn't imagine what was going on. Such a nice family. The FBI guy. The works. Apparently, Rausch's unassuming family man vibes were Oscar worthy. Now, the neighbor, still reeling, added his car wasn't even there. So we're like, what's the deal? They've been here forever, just blending in. Like, little did they know, Rausch was allegedly hiding a secret that could make your skin crawl. Yeah, that's right. Rausch is now cooling his heels in the Harris County Jail, probably rethinking some of those life choices. The investigation, a veritable alphabet soup of agencies, FBI, Harris County DA, Houston PD, Texas DPS, and Homeland Security, ensured that no stone was left unturned in the home. Oof, ladies and gentlemen, I don't know. I have 2 of these cases pending right now. And I've won 2 of my last 3 trials, but the one I lost was for this kind of stuff. Juries don't like it. And they can usually trace it back quite easily. And people get found out. And when you go to the federal system, if you're actually not just possessing, but you're filming it and sending it, you're looking at 15-year minimum to life. Let me just tell you, I've been very familiar with that statute lately as it relates to a client. So obviously, give the FBI analyst, Mr. Rausch, the presumption of innocence, but he has got some big trouble ahead his way. Of course, maybe you can always say there's an alternate suspect. Maybe it was his son's images. We'll see how that works out. Next on the docket, this day in legal history. Now, first of all, I forgot one from yesterday that I thought I have to do it. So yesterday in legal history, in May of 1627, Alice Young of Windsor, Connecticut, became the first person executed in North America for witchcraft. There you go. Had to include that. But let's talk about today. May 28th, 1830. President Andrew Jackson signed the Indian Removal Act, authorizing the forced relocation of Native American tribes, leading to the Trail of Tears. Now, the law sparked legal challenges over tribal sovereignty and human rights abuses, and while some tribes gave up their lands peacefully, others resisted. The Trail of Tears killed approximately 4,000 Cherokee in a forced march into the West. On this date, in 1908, Attorney General Charles Bonaparte was finalizing his plans for the Bureau of Investigation, later the FBI, created earlier in July to address federal crimes like land fraud, the centralized federal law enforcement agency. On May 28, 1918, the Department of Justice was pursuing cases under the Sedition Act targeting anti-war speech. These prosecutions tested First Amendment limits, influenced cases like Shrek v. United States, and there was further fallout on this day back in 1934 following the killing of Bonnie and Clyde. Congress was debating the 1934 crime bill, which expanded the FBI power to combat interstate crime, inspired by Bonnie and Clyde's crime spree across multiple states. Then on this date in 1975, the United States Supreme Court ruled in Breed v. Jones that transferring a juvenile to adult court after juvenile adjudication violated the double jeopardy under the United States Constitution. This influenced juvenile justice protections even to this day. And on this date in 1994, Congress was debating the Violent Crime Control and Law Enforcement Act, which was ultimately passed in September, and it funded 100,000 police officers and expanded prisons, fueling mass incarceration, and the debate goes with that. Here's something to think about. Our quote of the day. Eyewitness identification, while compelling, must be scrutinized with care, as human memory is fallible and susceptible to distortion under the weight of suggestion or stress. That's according to Dr. Elizabeth Loftus, a cognitive psychologist. And then our dumb criminal of the day. An ex-con's high-flying hustle. That's right. Drone deliveries trouble to Florida prison. In a plot twist straight out of a low-budget crime flick, Kahid Ash, a 46-year-old ex-convict with nearly 2 decades of prison time under his belt, has been nabbed for allegedly masterminding a contraband caper at the Martin County Institution in Florida. Court records reveal that Ash's weapon of choice wasn't a crowbar or a getaway car, but a high-tech DJI drone, allegedly used to airdrop illicit goodies into the prison yard. Now, the scene unfolded in the early morning hours of Wednesday, approximately at 2:45 a.m., when Ash, cloaked in black like a budget ninja, reportedly sent his drone soaring over the Indiantown lockup, home of roughly 1,500 male inmates. Prison officials, fed up with the recent spree of 8 pre-drawn drone drops in just 2 weeks, had developed a crack team of detectives to patrol the area. Now armed with a drone detection system, the cops mapped out a suspicious flight path favored by a certain DJI drone, smuggling phone, cigarettes, and who knows what else. Anyway, on May 21st, an eagle-eyed investigator spotted the rogue drone buzzing between the prison and a nearby work camp. Like a scene from a sci-fi stakeout, the cop tailed the drone to its landing pad, the roof of an SUV parked on a quiet roadside. Ash emerged from the vehicle as the drone swooped down, only to find himself in cuffs faster than you can say payload release lever. The drone, cops noted, was decked out with black tape over its light to dim its nighttime glow, a stealth move that screamed, "I'm up to no good." Ash, who lives about 40 miles from the prison, tried to spin a tail as flimsy as a paper kite. He claimed he was merely practicing his drone flying skills in the dead of the night near a prison because there's no traffic there. Unfortunately for Ash, law enforcement's database think traffic cams and license plate readers placed his SUV at the scene multiple times since late April, coinciding with the prison contraband bonanza. The drone's flight path conveniently matched the ones logged during those drops, while Ash's insisted his drone fancy package dropping lever was cargo free. Police weren't buying it. They slapped him with a charge of attempting to introduce contraband into a correctional facility and illegally flying a drone over a prison. Police underscored these stakes, smuggled items like phones and smokes, empower prison gangs, letting them flex their control like mob bosses in orange jumpsuits. Now, Ash, who walked free in 2017 after serving 19 years for a string of armed robberies, now sits in lockup without bond, awaiting his day in court. If the drone debacle proves anything, it's that old habits die hard, and sometimes they just take flight. Mr. Ash, you are our dumb criminal of the day. As they used to say in the military, good initiative, poor judgment. And guess what? The data is what it is, in the famous words of Karen Reed. It's going to show you flying. It's going to show that your car going there. I think a reasonable jury is going to conclude that you were doing it, Mr. Ash. Therefore, you are a dumb criminal of the day. Congratulations, you made it. That's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.